Hello and welcome to this latest edition of our Kohberger podcast. I'm David Rose here at Fox 13 Seattle. I'm joined by Ann Bremner, our legal analyst, who has been working with us closely as we followed every step in developments that have happened, and they seem to be happening pretty regularly now as we head toward the trial this August. Ann, thanks for being here today. I appreciate it. We had a big ruling from Judge Hippler this week. Judge Stephen Hippler ruling the defense would not be able to get the evidence, the DNA evidence thrown out in the trial. So can you break down a little bit about what that ruling was in the documents that you've read?
Sure. It is a pleasure to be on with you and an honor, of course, David. I think that there's a lot of court documents in this case that are pretty long, but they basically come down to the fact that there was a challenge to the DNA on the knife sheath. And the judge said there's no right to privacy in a crime scene, a piece of evidence in a crime scene, which seems to be just common sense. But that was something that the defense had argued, that there was a right to privacy in that sheath where the DNA was found that matched allegedly Kohberger, and that it was unlawfully seized. Well, the judge said no. He said that it's clear law that if there's no right to privacy there's no constitutional violation. And then we get into the whole method of going through DNA of ancestors or family members. And that's something that was also challenged, saying, well, you found out who he was through looking at these types of databases. Therefore, there's a constitutional violation. He said, no, there's really no standing here for the defendant, frankly, to challenge the procurement of certain DNA through that method. And then there's so many things in this case that the judge ruled. And these, of course, I said these are pretty lengthy rulings. But that's the DNA piece. I mean, like, it's like the defense tries to do surgery, surgically get rid of parts of a case. And the biggest part of this case, of course, is the sheath and the connection to the defendant. And the judge has ruled it's not going to change. They can move for reconsideration. I'm sure it'll be denied. But of course, it can be an appeal issue later on because it's a death penalty case. So it'll be an automatic appeal.
Well, the families were certainly grateful that the judge made what they considered a timely decision, made it within less than a month after that hearing in January. I look back at some of the other cases that I've covered involving genetic genealogy that were solved, and I thought I had not seen this particular tactic by the defense to throw out that it was a violation of privacy. I thought it was kind of a long shot. I think you thought that too.
I did.
So as we look forward in the case now, the big discussion over the last week has been these two other male DNA samples that were recovered from areas around the home. Now, we don't know if that's a bloody handprint. We don't know exactly what it is. We don't know if Kohberger planted, that DNA there, being the so-called criminal mastermind that some people think he might be.
Right.
But what does this do for the defense, or what does it do to mess up the prosecution's case going forward? Are people overreacting, saying that Kohberger is going to get off because these two other male DNA samples were found?
Absolutely. I think they'd be overreacting. This is a very strong case, and it could be DNA from, remember, this is kind of a party house, and you had a lot of students that lived there anyway. And we don't have any evidence that there's some person that could be connected to a crime when it was left or anything else. And when you're saying somebody else did it as a defendant, you've got to have kind of a train of circumstances to say, we used to call it the Saudi defense. Some other dude did it. There's something out there to say someone else did. The fact that there's other DNA, I mean, that was found in Amanda Knox's case, other cases. So it's not a smoking gun. And here's the other thing. When they were challenging certain of the warrants in this case, that there's something they asked for, which is called a Franks hearing. And that's a hearing where you say, I want to have an evidentiary hearing because I can show as a threshold to get that hearing that there was false information in the affidavit for the search warrant, or there was something or some things left out that would be material to the finding of probable cause by a judge. And the judge in this case denied the Franks hearing, said there was no evidence of either of those things, that things were withheld, omitted, or misrepresented. And if so, if there's anything like that, it would have changed the probable cause determination. So that's part of this too, which is, well, if they'd said in the affidavit that there was some other DNA, or said in the affidavit that one of the witnesses heard someone coming up and down the stairs, would it make a difference? And the judges said no. So no hearing on Franks.
Yeah, it's interesting. Kohberger reportedly said, who else did you arrest after he was arrested? And so I think some people are wondering, was he talking about maybe members of his family, or was he talking about perhaps that he had left other DNA at the scene and wondered to know if it worked?
That's an excellent point. And, the other thing in terms of looking at search warrants. I don't know if you want to get into this yet, but they had a no-knock warrant in Pennsylvania. And then he challenged the search of garbage, which you don't have a right to privacy in trash. And of course, he was out in his pajamas, wasn't it? And like 4 a.m, going to his neighbor's trash and getting rid of evidence. So there was a lot here to get rid of potentially by the defense, and they didn't. It was a grand sweep for the prosecution.
And you've represented a lot of people. You've defended a lot of people. How would you be feeling right now if you were his attorney about your chances in this case or about your strategy?
I'd be really worried. I mean, I think they did a really good job of at least raising some of these issues and briefing them and being meticulous. And I don't see now any other evidence that could really be challenged. And so the question is, here's a few things, I guess. How could it be that he could kill 4 people so quickly and not have any blood on him, like we know that he didn't, apparently? And what would his motive be? You don't have to prove motive, as we well know in prosecution, but why? Why would he, want to do something like this horrific crime? And so he might have messaged some of the individuals in this case. What does that prove? I mean, social media, people do that all the time. So I guess you have to kind of do it that way and hope that you can avoid the death penalty. I mean, a lot of times the win is to avoid the death penalty, to get some sympathy for him, some doubt about how could this happen? This is really astonishing that he was able to do this. But obviously he did, or someone did.
Well, let's talk about that a little bit, his mental state. Idaho doesn't have the insanity defense. We're hearing that the prosecution requested his health records, maybe even his mental health records. How does that play into this, his state of mind?
Well, it doesn't have the insanity defense. They don't in Idaho. And they also, of course, have the death penalty by firing squad. So why he committed the crime in Idaho instead of our state, Washington, where there would be an insanity defense and there would not potentially be the death penalty. So there's some evidence of the visual snow that he may have had. There's also some evidence of some heroin addiction, some evidence of some behavioral issues that he's had, with women, and including at Wazoo and in Pennsylvania. So looking at those kinds of things, I mean, but I don't see how they're relevant if there's no insanity defense. And I don't see how the state gets into evidence his poor activity, I guess you could say, or the way that he's treated women anywhere, because it doesn't really show he's a murderer.
And I guess it goes to what else we might not know. There was that 5-hour closed door hearing. In your experience, what happens in those kind of hearings and why aren't they open to the public?
Well, I think the judge has done a great job on the whole question of what's open to the public and what's not. Remember in the beginning, David, that they all stipulated to basically a gag order because it protects the defendant. You don't want to have a case where there's so much evidence out there that contain a jury that he's not going to have a fair trial. So that's what the judge is trying to do, is make sure that he gets a fair trial. And the other thing is, in terms of his constitutional rights, it's his right to a fair trial, but it's our right to basically scrutinize the proceedings, but basically for his benefit, that the public looks and can see the proceedings to make sure they're fair. So that's what's happening in these closed door hearings. And they're not necessarily the types of hearings that might be sensitive in nature, but they may be hearings where potential evidence may not come into evidence. And we know prosecutors ethically can't talk about evidence that may not come in tainting a case potentially. So I'd be guessing at what's closed, but I think the judge has been careful. A lot of pleadings in this case, from the get-go.
800 pages of court documents or something, just massive. How
Right.
difficult is it going to be, or how time-consuming to seat a jury in this case?
Well, we always say that you have to be living under a rock, especially in Idaho, right, to not heard this case. But that's not the test, as you well know. It's whether the potential juror, given whatever they may have heard, can set aside that information and hear the case solely based on what witnesses say and what evidence is admitted in court. That's the test. And jurors, they're presumed to follow the law. I've always thought in my very long career, jurors usually do. They take an oath. They say the highest duty of citizenship is jury duty. I think Abraham Lincoln said that. I think they rise to the occasion and they do that.
No, I always say that DNA doesn't lie, just because I've covered so many different cases and been involved here in Washington that ultimately the DNA, it came down to the DNA for the jury. I know the defense in this case is going to try to raise all kinds of questions. Were there other suspects involved? Was Kohberger not the suspect at all? What about that DNA on those other 2 men that have not been identified? Does the DNA really make all of the difference in this case, do you think?
I think it does. people could look at O.J. Simpson's case where it didn't, but they had a potential witness that had a bias, Mark Furman, that they argued could have planted evidence. They had things like that. And they also had a criminalist, Dennis Fung, that made a lot of mistakes, remember, not wearing gloves, things like that in the collection of evidence. I don't think they have that here. And keep in mind, it's been many years since that case. You know, DNA, I think to most jurors is CSI kind of evidence. And we know that the investigators have been very meticulous in this case. And it's been out there in the news that his DNA was on that sheath. And other people say, did he like plant that because he's like trying to do the perfect crime? Or was he like trying to show, catch me if you can kind of thing, like dropping a piece of evidence to, you know, to see if the police could even figure out who he is? But the bottom line is, it is what it is. It is the sheath to the murder weapon that has his DNA on it.
And I want to talk about one more thing, because I've seen a lot of criticism and controversy online about this. There was that hearing where they had the questionnaires for potential jurors, and they were asking, when they were talking about moving the case all the way to Ada County. And I think some people may have misinterpreted what that was all about. Can you illuminate a little bit why some people are interpreting that as to say that there was no proof that Kohberger might have been stalking one of the women?
You mean in terms of the change of venue? Because when you have a change of venue motion.
Yeah, they asked those questions. They had the 12 questionnaires that they were asking, and people seem to be focusing on that one question, asking about, had you heard there was a stalking in this case?
Exactly. So in order to get it, only the defense can ask for a change of venue. And of course they did in this case. And so part of that, at least in this case, and oftentimes is a survey to see, you can establish to the judge, look, this is our potential pool and we've got a problem. So just by asking that question doesn't mean that there were other suspects. It's simply testing out what this potential jury pool had heard or what their perceptions would be. It's not evidence, you know, it's not. And I keep seeing things on the web about this case, which I applaud that people want to participate in the system and understand these cases. But we can't try these cases in the media. We can't try them on the internet. We can't try them in chat rooms or, you know, any, you know, law and crime or any court TV, which I do. We have to try them on the evidence. And I think this is a case where you have to be scrupulous as the judge to protect the rights of the defendant, but also be transparent enough that the public can see what's really happening in the case.
Yeah. Well, yeah, we appreciate your time so much. We're going to talk so many times in the months ahead as we lead up to the trial. Hopefully we'll still continue to have the trial this summer. There won't be any major delays, but this was a big development this week with the judge denying the defense's request to throw out the DNA. We're going to delve into much more of this with Ann and our other specialists. That's coming up on our second documentary airing in early March. Stay tuned right here on Fox 13 Seattle, our YouTube channel, anywhere you get your podcasts, and fox13seattle.com. And thank you. We'll talk to you again soon.
Thank you so much.